Hi, this is Kip from Malik and Malik. Today I'm in the illustrious basement. Notice there's no files behind me. There used to be files. So, when I'm not being a workers' comp attorney, I schlep files and boxes to be recycled. So, um, we're largely a paperless office. So these are ancient files that had been recycled. But anyways, today I'm going to talk about a 10th district appellate case, a mandamus case. It's called Giant Eagle versus the Industrial Commission of Darius Jefferson. And if you notice, Giant Eagle's at the front part of the V, so that means it's their appeal. And what ended up happening was this Mr. Darius Jefferson, he'd fractured his finger on July 12th, 2022. And it looks like that same day he returned back to work after going to the hospital, and then he was terminated for allegedly threatening his coworkers. That's at least what Giant Eagle's position was. So they booted him, they fired him, and then he was certified off work starting July 18th, 2022. That's when he went to his occupational medicine doctor, and then he was certified off work, and he submitted a C-84 requesting comp. It went to the DHO and SHO, and both the DHO and SHO granted comp. Giant Eagle, again, going with the 412356F kind of thing, their whole thing was his wage loss was directly related to reasons unrelated to the impairments stemming from his allowed workers' comp claim. So the second sentence of 412356F, they're indicating that applied. And what the DHO, SHO, and ultimately what the 10th District stated as well was that using Autozone, and Autozone's this very helpful case for injured workers, but using Autozone's interpretation of 412356F, which I would argue is the correct interpretation of 412356F, but the singular question for Mr. Darius Jefferson was whether he was unable to work as a direct result of impairments arising from the allowed conditions in the claim. So if the answer is yes, Darius gets temporary total disability. The 10th District and the DHO and SHO basically saying, relying on Autozone, Darius was not required to establish that his inability to work was only due to impairments arising from the allowed injury. So there could be other reasons why he's not working, but as long as if you hit that first sentence and that first sentence applies, then you don't go the second sentence. So, and I think this is a good decision. I think I think it's good that the 10th District is applying Autozone. Here's the deal with Autozone is being taken up, or I believe it is, to the Supreme Court of Ohio. Hopefully the Supreme Court maintains what the 10th District has set out in Autozone, but we'll see. And then just a quick primer on Autozone for everyone. In Autozone, the dude had a work injury. He was released to work with restrictions. I think he cursed somebody out, or he had some kind of disagreement at work, and he got booted, terminated for cause, whatever. And then a week later, he ended up having surgery, which was authorized through the claim at the allowed conditions in the claim. And so the DHO, SHO, and then the 10th District in that case basically said, again, is the reason he's not working directly related to the allowed conditions in the claim? And if the answer is yes, you don't go to the second sentence of 412356F. And so even though he's terminated, he's still entitled to comp in that case based upon the date of surgery. So that's how Autozone applies. And the other thing is, not that it's really relevant, because it's really not under this analysis, but the other thing that Giant Eagle really didn't have their ducks lined up, what they ended up doing is they ended up, and the DHO noted that Giant Eagle supplied no statements from these witnesses who were allegedly threatened by this Mr. Jefferson, and then there's no documentation he was reprimanded or anything prior to being terminated. So I don't know. It's kind of wonky to me. If you're going to come, bring all the evidence, nevertheless, it was denied. And you're kind of wondering why, if there's no substance to Giant Eagle's position, why'd they fight this? Like, why'd they put this Fugazi argument? I don't know. My assumption is it could be any number of reasons, ranging from billable hours, that's they get paid per hour, to possibly wanting to continue to chip away at AutoZone and how that applies in Ohio. So, but yeah, that's kind of the deal with this thing. So that is Darius or Giant Eagle versus IC and Darius Jefferson. And what I'll do is I'll put a site to that case in the description. And as I say at the end of all these videos, workers' comp is a super complicated beast. Don't do this stuff yourself. Get consult with a workers' comp attorney. Ask your friends, family, coworkers, doctor, whomever, who do they recommend, and then call that person. And if you need to call a bunch of folks before you land on somebody, that's fine. Go ahead and do that. Anyways, this has been Kip from Malik and Malik. Stay safe. Thanks for watching this video.